Hi, I'm Mike Kalish, the Social Security lawyer. I'm an attorney located in Southern California, and my law practice is focused exclusively on representing claimants on claims for Social Security disability benefits. In today's video, I'm going to talk a little bit about the hearing. So let's set the stage. You applied for your disability benefits. Maybe it was a couple years now since you applied. Social Security denied the claim. You timely filed your request for reconsideration. They took a second look at your claim. They still said no. When you received the second denial, you timely filed your request for a hearing. That was maybe about a year ago. And now the day has finally arrived that you're going to go in and have your hearing before a real live judge and explain to the judge why you feel you're unable to do any type of work at all and you should be awarded your benefits. Let's step back a little bit and set the stage. First of all, first things first. Before the hearing, Social Security should have sent you something called a notice of hearing. On the notice of hearing, it's going to say the date that your hearing is scheduled for. It's going to have the time. It'll be signed actually by the judge who will be hearing your case. And it will have the location for where the hearing is going to be held, where the OHO office is. That's the Office of Hearings Operations. That's what they call these offices nowadays. Be sure that you review that carefully. A lot of times people get these notices and they think, I've got to go see the judge, I've got a court appearance. They know where the local courthouse is, and they make the assumption that the hearing is going to be in the courthouse. It's a fair assumption, but it's usually a wrong assumption. So make sure you know where you're going. Look at the address. If you're not familiar with it, Google it. You want to make sure that you know exactly where you're going. You don't want to end up in the wrong place and then have to be frantically trying to get to the right place after you figured out that you're in the wrong place. So review the notice of hearing. That's why they send it to you. Also, make sure that you understand what time you need to be there. They'll put the time of the hearing, and in the notice they'll say they would like you there at least 30 minutes prior to the hearing. So time it. Make sure that you can get there. The other thing is check out the parking. If you're going to be driving down there, you should be aware Social Security will not validate the parking. So if it's paid parking, you need to know that and be prepared to pay for the parking. Some of these places don't really have parking available. So figure out where you're going to park if you get down there. You don't want to get there and then realize you can't find parking and end up being late for your hearing. Don't want to do that. So make sure you know where you're going. Make sure you know what time you need to be there. Try to be there 30 minutes early. And then make sure you have got the parking situation scoped out if you're going to be driving. Okay, let's talk about the hearing itself. You get there, you show up at the hearing office, you're going to walk in the door, there's going to be a security guard there, you're going to check in with the security guard, they're going to do their little security drill like at the airport, they'll wand you down, they'll make sure they'll have you sign in. Then the security guard may direct you to the receptionist to check in, to let them know that you're there for your hearing. If you are representing yourself without an attorney, they should have a CD prepared with the file. They should be able to provide that to you. If you are there with an attorney, then they will not anymore provide the CDs. They used to provide them to everybody. Now, if a claimant is represented by counsel, they assume that the attorney has access to the claimant's file prior to the hearing. They'll have, usually in most of the hearing offices, they'll have, there's a waiting room area. It sort of looks like a doctor's area. You go in there, sit down and wait for them to call you. And there's also usually a couple of little conference rooms where you can meet with your attorney in private and go over last minute issues, update any paperwork that needs to be updated, that sort of thing. All right, so who's going to actually be in the hearing? So let's go over the cast of characters. Well, of course, there's going to be a judge. And this judge is somebody, the formal title is an administrative law judge. They are real judges, they are federal judges, but their practice, what they focus exclusively on is hearing these types of disability claims or any kind of claim that deals with Social Security. Most of these guys, these folks are attorneys. In fact, all of them, you have to be an attorney. You have to have been in practice for at least, I believe it's 5 years before you can apply to be a administrative law judge or an ALJ. They are trained in Social Security matters. They understand the rules, the regulations, the relevant case law. So they've got the background, the experience. Some of them have maybe come up through the system within Social Security itself. They may have been attorney advisors to other judges earlier in their career. They may have been writers who helped the judges write their decisions. They may have been recruited right out of the private workforce, attorneys who applied and decided they wanted to be a judge. They are lawyers, and they are lawyers with some experience, so they know what they're doing. So that's our judge. In addition to the judge, you're going to have somebody there called a hearing monitor. That's just a person who's there to assist the judge. There's going to be some recording equipment, the computer systems, the phones, that sort of stuff. They're there to just sort of help the judge get through the hearing, and it's basically act as the judge's assistant. They'll take any paperwork that the attorneys may have, updated paperwork, last-minute evidence, that sort of thing. The other people that are going to be in your hearing is there will be some experts. For sure, there'll be a vocational expert. The vocational expert is a job expert. It's a person who has a background and qualifications in job placements. They understand the requirements for jobs, and they're there to provide some expert testimony to the judge concerning the kind of work that you've done in the past and whether or not there be any jobs available for an individual who had the limitations that the claimant is alleging is keeping them from working. What you need to understand is that the vocational experts are not trying to defeat the claim. They're not working against the claimant. They are there strictly to provide objective, expert information about jobs, about employment, and about the types of skill sets that are required to perform a particular job, the physical requirements of a job, the skill sets that are needed to do the job. And they will give testimony, and they usually give testimony toward the ends of the hearing, but different judges may do it a little bit differently. But that's the purpose of the vocation expert. And I'll give an example of how they play into this in a bit. Other witnesses that might be there are something called medical experts. These are usually doctors who are retained by the Social Security Administration to give expert testimony concerning medical issues in your case. The judge, as I just explained, is not a doctor. The lawyer who's sitting next to you is not a doctor. Very likely that you are a doctor, and yet everybody is looking at your medical records and trying to make heads or tails out of it and come to a fair decision. So it may be helpful to the judge to have a medical expert there to explain to the judge what the records say. And again, the medical expert is not there to work against you or to try to prove that you can still work or defeat your claim. They're there to provide expert medical testimony concerning what's going on in your medical file. So sometimes they're there, sometimes they're not. A lot of these cases, after a while, the judges see the same kinds of medical issues pop up, and they may not feel the need to have an expert testify. But sometimes there are very esoteric medical conditions or unusual conditions, and the medical expert will be there to clarify those issues to the judge and explain it to the judge. This is what's going on based on what I see in the medical records. The medical expert should have been provided a complete copy of your file, certainly the medical records, to review before the hearing, so they're going to understand what's going on, at least from the written medical records. Obviously, the medical expert has never actually examined you, so their opinion is based solely on their review of what records were provided to them. All right. They'll give an opinion, they'll explain to the judge what they think about what's going on medically, what the diagnoses are based on their review of the medical records, and they'll give the judge an opinion concerning what kind of limitations somebody with the records that they've reviewed would have. In other words, okay, I saw that this person was on dialysis, therefore I don't think that he'd be able to show up to work, or I think that with this back problem, the most he could stand would be 4 out of 8 hours out of a day, but he might be able to sit for 6 out of 8. So that's what they're going to do. They're going to give an opinion to the judge concerning what the limitations are in light of what they see in the record. And you have to remember here, their opinion is based solely on the record. They have never had the opportunity to actually examine you. You might have medical doctors, they could be internists, they could be orthopedics, they could be rheumatologists, They could be psychologists if it's a psychological issue, or a psychiatrist if those issues are in play. And again, they're not there to defeat the claim. Their purpose is to help the judge come to a fair decision based on the records. Other witnesses that are going to be there are, of course, yourself. The claimant will have an opportunity to testify and explain in their own words to the judge what is going on, all right, and why they feel that it can't work. You'll have the attorney there, and hopefully the attorney will be prepared to answer questions, prepared to question the other these witnesses, the vocation expert, any medical experts if it's necessary, and to make a cogent legal argument as to why you should get your disability benefits. Now, sometimes claimants ask me and say, well, I'd like to have some witnesses testify for me too, people who know me, my husband, my kids, etc. Different lawyers will handle that differently. You certainly have a right to bring in witnesses. My take on that is if the witness is simply going to say again what the claimant is going to tell the judge, right? If it's just going to be repeating the claimant's testimony, then that becomes redundant. It's kind of a waste of time. So I like to use witnesses when the witness is going to provide something that the claimant themselves are unable to provide. Okay, so we have our witnesses. We have the witnesses. We've got our expert witness, the doctors, maybe the one or two witnesses for the claimant. The claimant's going to testify. We've got the lawyer, obviously, there, the judge, the hearing monitor. Now, who's not there? Who's not there? And this is very important. There's nobody there arguing on behalf of the Social Security Administration. There's no opposing counsel, right? So the claimant is not going to be subject to cross-examination. There's no one going to be sitting in the hearing room with you arguing that you don't deserve your disability benefits, right? And because there's really nobody on the other side at the hearing, these hearings are referred to as non-adversarial hearings. And what that means is we don't have two lawyers banging heads. These hearings are much more of a information process. Now, you're going to be sworn in. You have to tell the truth. You're going to be under oath. The hearing testimony is going to be recorded. There's going to be a transcript, so if at some point somebody needs to review things, it'll be available to them. As I said, the witnesses will also be sworn in and provide testimony under oath. But there is not going to be any cross-examination of the claimant. Now, the judge will ask questions directly of the claimant. And that brings me to another point. A lot of these hearings, different judges have different styles, but a lot of times the judge will take the lead in asking the questions. Usually in a trial situation, the judge will sit back and let the lawyers sort of bang it out, and the judge plays referee between the lawyers. At these hearings, at these informational hearings, what's going to happen is a lot of times the judge will take a much more proactive role in questioning you, asking you questions. And some judges do. Other judges prefer to say, okay, the claimant has showed up with an attorney, let's make the attorney work and earn his pay. So they'll hand it over to the attorney, and that way they're free to take their notes while they listen. They'll ask some follow-up questions. Either way, doesn't matter. It's going to be the same types of questions. And what the judge is going to be asking you about, if you're the claimant, the questions are going to divide up into three broad categories. It's going to start off asking about background information. Are you married? Where do you live? What kind of work did you do in the past? How high did you go in school? Did you ever serve in the military? Et cetera, et cetera. And then he's going to get into the questions of well, are you working now? Presumptively, the answer is going to be no. He's going to say, why not? The answer is, I'm in too much pain, whatever the issue that's going on. And then the judge is going to get into the tell me about the pain questions. And he's going to ask a series of questions that are going to involve, basically where does it hurt? How much does it hurt? What kind of medications are you on? What are the doctors telling you about this? How long do you feel that you can stand? How long do you feel that you can sit? How much can you lift? What about concentration, focus, your ability to stay on task? He's going to ask a whole bunch of questions concerning your medical conditions. And the thing about this is it's actually, sometimes people want to they get concerned, they're nervous, and they want to really explain to the judge they can't work, and they start trying to talk about what the doctors are telling them or what their interpretation of what the doctor. And what the judge really wants to hear, what's important for you to do at this point, is just tell the judge how you feel. Right? This is really your opportunity to speak one-on-one with the judge and explain to the judge. It's the first time in this whole process that began a couple years ago that you actually have the opportunity to face a human being and say, this is why I can't work. This is what's going on. Subsequently, after that, once you're questioning, the judge is done asking you questions, your lawyer will have a chance to ask some follow-up questions. And then the judge is going to pose some hypothetical questions to the vocation expert. And these are very strange sort of questions, but they're going to be, the judge is basically going to be asking the vocation expert hypothetically, so it's not your situation, but hypothetical person. He's going to provide hypothetical is going to sound something like this. It's going to please assume an individual of the claimant's age, education, vocational background. Assume that this individual could stand on their feet for 6 out of 8 hours. They could sit for 6 out of 8 hours. They could lift up to 25 pounds frequently or occasionally, and 10 pounds frequently. Could that person do the claimant's past work as a cashier? And the vocation expert will probably say, yeah, that person that you described to me could, right? And then you're going to be sitting there saying, I can't do that. I can't stand that long. I can't sit that long. And that's okay. That's why we call them hypothetical questions, right? And what the judge will do is he will then ask more hypothetical questions of the vocation expert that will begin to sound more and more, should begin to sound more and more like you. Until finally the vocation expert will say, no, that's too many limitations, Judge. This person couldn't do their old job. This person couldn't do any other kind of job full time. If the judge does not reach that point, the attorney should take over the cross-examination of the vocation expert. The judge will ask the attorney, well, Mr. Attorney, do you want to cross-examine? And the attorney should say yes, and then ask questions based on your testimony there in the hearing, as well as what your doctors have said your limitations are, as well as the limitations that are recorded in your medical records. And then hopefully the attorney will be able to get to the point where the vocation expert will be able to testify and say, no, that's just too many. If that was the case, that's too many limitations, and that's it. That person couldn't work. At this point, the hearing is going to be over. The judge will usually take the matter under submission, regardless of whether he says, maybe about 25% of the time they'll say, yeah, I'm going to put you on. Most of the time they don't, all right? But in any event, regardless of what they say at the end of the hearing, the judge is still going to have to write up his decision. They're required to do that. And it's going to take anywhere from 60 to 90 days to get the judge's decision. The judge will either say, yes, I find that person meets the definition of disability, and he'll order Social Security to start making the payments that you're owed. He'll say no, it's an unfavorable decision. The claimant did not carry their burden of proof. I find that there is still work that they could do. Or say he'll give a partially favorable decision, meaning, well, I'm not going to give the claimant everything that they were asking for, but I do find that more recently they did become disabled, and therefore I'm going to give them part of what they were asking for, and they'll get their checks going forward. That's a quick summary of what a hearing is about. It's a little more detailed than that, of course. If you have any questions, please give me a call. My phone number is 714-548-3292. The website is www.thesocialsecuritylawyer.org. And I hope you found this useful, and thank you for watching today.